Good morning, everyone. My name is Binyamin Kaminetzky. I'm an attorney at Davis Polk & Wardwell in New York. I am also involved in the Beis Din of America, and it's a great pleasure for me to welcome you to this session featuring one of the true quiet heroes of the American Orthodox Jewish community. I'm sure you've all had the following experience. You hold an organization, whether it's Jewish or otherwise, in high regard, and then you get involved. And once you are on the inside, once you see how the sausage is made, you are disappointed and you view that organization, and your view of that organization plummets. Since I got involved in the Beis Din of America, I've had just the opposite experience. After getting a glimpse of how the sausage is made, my appreciation, admiration, and reverence for the work of the Beis Din of America has increased exponentially. Be it the professionalism, independence, and absolute impartiality of the Dinei Torah arbitration process done under the auspices of the Beis Din of America, and I commend you to read the anonymized opinions that were recently issued by the Beis Din of America in their arbitration cases that you'll find in your welcome packet in the Beis Din Journal. Whether it's the kind of the scholarship and independence and fidelity to halacha and the law that's reflected in that opinion, or, and apropos to the topic of today, the extraordinary care, empathy, compassion, discretion in which the Beis Din attempts to resolve the most sensitive divorce and family issues, with absolute, again, uncompromising fidelity to halacha and the law. And just to give you an example, halacha I don't have to talk about. As you know, we're under the leadership of Rav Gedalia Schwartz and Rav Willig from Yeshiva University. But this summer, just to give you an idea of how seriously we take what we do, lawyers spent literally hundreds of hours this summer going through the prenuptial agreement, which you're going to hear about today, looking at the law of how many different states? 20, 25 different states, to make sure that the prenuptial agreement would be enforced by courts in the various states that we looked at. Literally hundreds of hours to make sure that we know that we're doing things as appropriately and as accurately as possible under every possible scenario that we could imagine. I'm literally awestruck by the work of the Beis Din, and a big part of that is through the leadership of the Menahel, the director of the Beis Din America, Rabbi Shlomo Weissman, who is today's speaker. Rabbi Weissman received his smicha from REITs in 2001 and recently also earned his Yad smicha from YU this past spring. He is a graduate of Yeshiva College and then Columbia Law School, where he was a Harlan Fiske Stone Scholar and where he graduated in 2001. Before joining the Beis Din of America, Rabbi Weissman worked at some of the most prestigious law firms in Manhattan, including Debevoise and Plimpton. So it's with great honor and kavod that I introduce Rabbi Shlomo Weissman, the Menahel of the Beis Din of America.
Thank you very much, Ben. Thank you for that introduction, but also thank you for your increased involvement over the past year in the governance of the Beis Din of America. Ben joins a short and formidable list of lay leaders that we've been blessed to have at our helm in the modern era of the Beis Din of America, dating back to the mid-1990s, starting with Shelley Rudolph, Alav Shalom, a past president of the OU, who served as our president in the early 2000s. Eric Goldstein, who is now the Chief Operating Officer of UJA Federation of New York. Most recently, Alan Fagan, who now is the Chief Operating Officer of the OU. And so, Ben, we hope that you, before you go to some huge, big organization that dwarfs us in size, you will serve us in the able way that you've shown until now that you're committed to doing. I'd like to talk a little about the prenuptial agreement. I'd like to start by describing the agreement briefly, talking about its advantages and what a groundbreaking and important document it is. And then hopefully at the end we'll have time for questions and answers so we could have a dialogue about the agreement and its importance. The best way to describe the prenup Best way to describe anything, perhaps, is with a story. So I'll start with a story. In the fall of 2005, a husband and wife with one child started to get divorced. They separated in anticipation of divorce. They had married years earlier, a few years earlier, in an Orthodox wedding ceremony, and things had not gone well in their marriage. The husband filed for divorce, and early on in that divorce process, he approached his wife and recommended that they present themselves to a Beis Din to arrange a get. And for whatever reason, the wife declined. She said, "I'm not interested in a get, leave me alone." Their divorce proceeded, and by 2008, the couple finally finished their civil divorce process. And at this point, the husband realized he needed to get more serious about getting a get. He really needed a get in order to move on with his life. And so, at this point, when the wife continued to refuse to receive a get, he contacted the Beth Din of America to send a hazmana, a summons, to summon the wife to come to Beis Din. Now, I serve as the menahel, as the director of the Beth Din of America, and almost always I can't really tell stories about the cases that come before us because of the promise of confidentiality that we make to the people that come to us for our services. But every once in a while, a case makes it into the public record, and as we'll see in a moment, this is one such case. So as it turns out, this couple had signed what's known as the RCA, or Beth Din of America, Prenup. Let's take a moment to talk about what exactly the Prenup says, what it provides, and then we'll continue the story. The Prenup says, essentially, it's a relatively simple document. It says that from the day the couple separates until their divorce as a matter of Jewish law, in other words, until the get is given, the husband owes the wife $150 per day. Now, if the wife doesn't cooperate with the process, for example, at any point she declines to receive a get, even though the Beis Din suggests that she receive the get, so the support obligation isn't collectible, it goes away. But assuming that's not the case, this $150 accrues per day until the get is given. The idea here clearly is to provide an incentive for a husband to give a get earlier in the process rather than later in the process. And as we'll see, it works well. Now, in order to follow this story, it's important to realize that in May of 2008, we added a slight tinkering to the agreement. We added a sentence that says that the support obligation really only begins to accrue from the moment the wife notifies the husband of her intent to collect the support. And so, for example, if they separate, but the wife doesn't notify the husband of her intent to collect the support, the $150 a day doesn't begin to accrue. It only begins to accrue once she sends a notice to the husband that she intends to collect the support obligation. Now, the case we're talking about was governed by the old prenup. And so at this point in the story, when the wife was contacted by the Beth Din of America after the finalization of their civil divorce to receive a get, the wife responded that she was prepared to receive a get, but only if the husband first paid her $108,000, representing the $150 a day obligation for the roughly 2 years that it took for them to get civilly divorced. Even though she had declined to receive that get, there had never been a formal Beis Din proceeding in which she did that, and so she, reading the literal terms of this document, insisted that he owed her $150 a day, $108,000, and she wasn't prepared to receive the get until he would pay her the $108,000. The husband, of course, argued, nothing doing. He said, I was prepared to give her a get from day one. Why should I pay her $108,000? That's crazy. And so they ended up coming to a hearing before the Beth Din of America in front of a panel of 3 dayanim. The wife maintained her literal reading of the agreement. The husband said, I don't owe her a penny. And the Beth Din convened. They convinced her that it was in her best interest to receive the get. Regardless, she received the get, and we promised her a written decision on the merits of her monetary claim for the $108,000. A few days later, the panel issued a written determination rejecting the wife's claim for $108,000, but awarding her $10,200. This amount reflected the daily support obligation accrued from the date of their separation until the date the husband first approached the wife and suggested they get a get. Now, both the husband and the wife were upset. Now, the ex-husband and ex-wife, they were both upset. The husband thought he shouldn't have to pay anything, let alone $10,200. The wife still thought she was entitled to $108,000. Now, one of the unique features of the Beth Din of America, of our arbitration process, is that under Section 31 of our rules and procedures, we have an appeal process where a non-prevailing party can appeal the decision of the panel to the Av Bezdin, to Rav Gedalia Dov Schwartz. And the way it works is that you submit a written appeal. The appeal has to be, you have to present it under one of a number of conditions, one of which is that the decision reflects a mistake in Jewish law. And so in this case, both of them appealed. Now, Rav Gedalia Dov Schwartz, the Av Bezdin, has the authority to delegate it to a different dayan, and in this case, he delegated it to Rabbi Mordechai Willig. Rabbi Willig was a good choice, not only because he is an expert in these issues, but he's the prime architect of the prenup. And in March 2009, Rabbi Willig handed down a ruling modifying the lower Bezdin panel ruling and concluding that the husband didn't owe anything to his wife. And the clear intent of the prenup, he reasoned, was to give a good incentive for the husband to give a get early in the process. In this case, the husband was prepared to give a get. In fact, he was the one who was always advocating giving a get, and he shouldn't have to pay anything. Now, predictably, the ex-wife was now really upset, and she promptly went to secular court to argue that an arbitration organization can't overturn its own ruling. And at the very least, she should be entitled to the $10,200 that the lower panel had awarded her. And finally, in 2011, in my favorite judicial decision ever written, the court upheld Rabbi Willig's decision, and the husband now, at the end of the story, was permanently off the hook from paying the wife anything under the prenup. It's my favorite decision for 4 reasons. Number one, it upheld our conclusion. Number two, it spoke favorably about our process and specifically affirmed our appeal process under Section 31 of our rules and procedures. Number three, it actually went further and said that Rabbi Willig's ruling made sense. It was the most equitable way to handle this case. And number four, if you look at the dates in the decision, you see that the civil court process took a full 2 years, convincing anyone who would have thought otherwise that the process at the Beth of America is much, much more efficient than any litigation in secular court. I like to tell this story because it sheds light on the nitty-gritty mechanics of the prenup, how it's technically structured. The case and its pathway through the Bezdin and secular court system also demonstrates in a very real way, that this document isn't just symbolic. It's a real legal instrument that depends on court enforceability to accomplish its goals. And the Beth of America, even in an anomaly like this case, vigorously administers the agreement and ensures that it's interpreted justly and fairly. I should mention at this point that the Postnup works identically to the prenup. Many people who got married before there was a prenup have signed postnups. My parents are in the audience. They just signed a postnup last week, I think. It's a great way to show support for the document and to spread awareness about the document. The truth is that this story isn't typically what happens. Much more often, almost always, the prenup works in the way it did in the following case. This case happened recently over the past several months, but the same description applies to scores of cases that have developed over the years before the Beth of America under the prenup. In this case, a couple had an Orthodox wedding, and they lived outside of the New York area. Their marriage ended in acrimony, and for several years they were engaged in difficult litigation in civil court. At some point during this process, the wife began to ask the husband for a get, and the husband indicated he wasn't prepared to give it to her. And even at times, he suggested that he would not be prepared to give her the get until he was satisfied with the custody and financial outcome of their divorce case. And so the wife began to get worried, and she contacted the Beth of America to open up a file, and she realized she had signed a prenup. She presented the prenup. We began sending out hazmanas, summonses to the husband. We sent out one summons, there was no response. We sent out a second summons, there was no response. And I finally ended up on the phone with the husband just after we sent out the third hazmana, the third summons. And when I spoke to him on the phone, the husband complained bitterly about the raw deal he was getting in secular court. And he let me know that he wasn't going to give a get until his wife relented and gave him what he thought he was entitled to in their divorce process. I calmly explained to him how the prenup worked. He didn't seem to move the guy. I suggested that he speak to his lawyer to talk about his exposure under the prenup. That didn't seem to move him either. We sent one final letter indicating to him that we were prepared to schedule an arbitration proceeding pursuant to the terms of the prenup. And within 3 days after we sent that letter, the guy calls me up and he tells me he's prepared to give a get. That case, or something similar to that, happens all the time. Now, it's true, inevitably, there are going to be cases. There are going to be cases where the prenup doesn't work. Classical aguna cases where a husband just goes missing. Cases that we find every once in a while where a husband just falls off the grid, he's got no assets and no hope, and he's essentially judgment-proof. And it's not clear in those kind of cases whether a money judgment against him is going to convince him to give a get. But in the vast, vast, vast majority of cases, the challenging aguna cases that we read about in the newspapers, that afflict people that we know, neighbors and friends of ours, that command an inordinate amount of time of our Beis Din and other Batei Din, cases where the halachic institution of the get is utilized, sadly, as a tool of extortion, causing a chilul Hashem and sullying the name of Torah. In all those cases, or in the vast majority of those cases, the prenup has worked smoothly and spectacularly. There's something very compelling about the structure of the prenup. Rather than seeking to undermine or fundamentally change the halachic process, it reaches back in time and it elegantly restores the authority of the community over the individual in the realm of the get. Think about what's brought us to where we are today and how the problem of the modern day aguna developed. The Torah tells us that before Yisro advised Moshe otherwise, Moshe Rabbeinu sat and heard cases min ha'erev ad ha'boker. Min ha'boker ad ha'erev. From the morning until the night. The Talmud teaches us that this phrase harks back to the erev and boker of Ma'aseh Bereshis, of the creation of the world. Why? Why the connection between hearing cases and the creation of the world? The Gemara tells us, Kol dayan shedon din emes la'amito, ma'ala alav ha'kasuv, ki lunasa shutaf ha'kadosh baruch hu b'Ma'aseh Bereshis, that a judge that adjudicates cases honestly and appropriately is akin to a partner of the Ribono Shel Olam in the creation of the world. And again, why that connection? So the Bach, in his commentary at the beginning of Choshen Mishpat, says that this connection is because the continued existence of Shemayim and Aretz, what keeps the sky up and what keeps the earth intact, is the social order that a working system of law ensures. Without a strong judicial system and without the rule of law, there's anarchy. And the world in which we live, in the heavens and the earth, just can't tolerate a society without justice. But from this perspective of a strong Jewish judiciary, of an intact Beis Din system, in 2014, on the eve of 2015, in North America, the sky is falling. There's no universally recognized Beis Din. There's no centralized communal structure. There's no empowered rabbinate. There's no authority to tell people what to do, to tell men and women in the divorce process or in any process how to behave in accordance with Torah values. For all the benefits of a decentralized communal structure, and there are many benefits to a decentralized communal structure, local autonomy, multiplicity of communities, diversity, there are also some downsides, and one of those downsides is that a get can be withheld with impunity. Without a Beis Din that's both empowered and prepared to justly adjudicate cases, the decision of when to give a get or whether to give a get is left to one divorcing party's unilateral discretion. That's a recipe, inevitably, for the abuse of the Torah system of divorce. It's a recipe for disaster. And that's precisely how it's played out over these years. There are women out there, again, our friends, our neighbors, people we know, who simply can't remarry. despite the functional end of their marriages years ago. We've dealt at the Beis Din with cases of husbands who've withheld gittin, made explicit demands for money for gittin. We've seen women of childbearing age who have been denied gittin for years, 1 year, 2 years, 3 years, more, where their inability to date and move on with their lives has a real effect on the trajectory of their lives. I've seen insane cases of agunas who have been agunas for 17 years, 20 years. But the prenup, when it's signed, is like a magic potion that just magically reverses this state of affairs. When a couple signs the prenup, we know that the get won't be improperly withheld because there's a disinterested third party, the Beis Din, that will step in to determine the proper time for the get to be given, and importantly, it has the power of the purse to back it up. And what's encouraging is that quietly over the past 20 years, the solution of the prenup has emerged more and more as the long-term solution, really the only promising long-term solution to the aguna problem. Think about this. When it was first proposed in the mid-1990s, the promoters of the prenup, the initial promoters of the prenup, had to strike a confident tone about the kind of solution they were proposing and its effectiveness. Because its effectiveness depended on everyone's participation. If the prenup had held any promise of working and ending the aguna problem, that could only happen if it were routinely signed by brides and grooms when they got married. If nobody signed it, or more likely, if the only people to sign it were the ones least likely to withhold gittin, then the solution certainly wouldn't work. And yet these initial drafters of the prenup, the initial promoters of the prenup, couldn't really have known with certainty in its very earliest days whether this was a real solution that would work. Would the agreement actually hold up in court? Would courts actually support awards issued by the Beis Din under the terms of the prenup? Would money judgments actually work to convince husbands intent on trading money for a get to give a get? Would young couples actually sign the document when they got married? They couldn't have known for sure if the prenup would be just one more tool that would chip away at the edges of the problem, or if it would offer a real, robust, long-term solution to the problem that wasn't going away. This morning, 20 years later, the picture is entirely different. And we have in our possession a real and tested antidote to the aguna problem. It's even been court tested. In December of 2012, in Light v. Light, a Connecticut court upheld the constitutionality of the prenup. The court gave what we've always known was the correct answer. The prenup represents a neutral, secular contractual agreement, and it doesn't violate any of the constitutional doctrines that would ordinarily bar a court's involvement in a religious controversy. And that 2012 ruling set an important precedent for other courts to follow. But more importantly, the picture is different today because we have practical precedent. Over and over again, the prenup has worked in the background to prevent potential cases of igun. Sometimes it doesn't even have to be mentioned. Both parties know it's there, and they know how to behave appropriately in their divorce negotiations because they know the consequences if they don't. Sometimes, like the case we just discussed, the couple needs to be brought to, or the husband needs to be brought to the brink of a din Torah hearing, and ultimately the prenup works. Sometimes we even have to go further and actually hold a hearing and issue a decision. But time and time again, in case after case, the prenup has yielded its positive results, even in the most acrimonious divorce cases, when it seemed improbable that anything would work to get a timely get. Now, like anything new, we can't expect immediate, universal adoption of the prenup. But I'm hopeful that as time goes on, and as the experiment of the prenup continues to succeed, more and more segments of the Jewish community, of the Orthodox Jewish community, will adopt the prenup and begin insisting that it be signed by young couples. For those who have questions about the halachic propriety of the prenup, those are important discussions that need to take place in the public realm and among poskim. But you've probably heard some of the cultural arguments against the prenup. People say that it's not romantic. People say that it's awkward to raise issues of igun and divorce for a young couple in love and about to get married. Or they've said that having a prenup This was actually reported in the newspaper 2 years ago by a prominent member of the Orthodox community, that the prenup brings the possibility of divorce to the forefront, making it a real option when couples who are having marital difficulties should be focusing on improving their marriage, not thinking about divorce. Now, intuitively, many of us reject these arguments, especially the last one, because we live in a time where divorce is not a secret. Divorce is not a rarity. Everyone knows about divorce. It's hard to imagine that raising the issue of divorce, talking about divorce with a young couple, actually significantly or at all changes the psychology of a couple. That's an intuitive argument, but now we actually even have some statistics to back up this argument. A few years ago, an old friend of mine, Rabbi Shmuel Maybrook, moved to Passaic, New Jersey with his family. That's where my family lives. And we invited the Maybrooks over for a Shabbos lunch. And the conversation at the Shabbos table turned to what his wife, Rebbetzin Chani Maybrook, was doing. She was at the time finishing up her doctorate in psychology. And at the Shabbos table, we started talking about what she was writing for her dissertation. And she told us that she was writing about marital satisfaction. She was going to conduct, or she was just starting then to conduct a survey of married people in the Orthodox Jewish community. She was going to send out the survey and collect the data and write about the things that affect marital satisfaction in the Orthodox Jewish community. And because of my line of work, I said to her, you should throw a few questions in about the prenup. I didn't know what the connection to marital satisfaction was, but I figured couldn't hurt, get some data about the prenup. And that was the end. I completely forgot about that conversation until this past July, when I got an email from, she's now Dr. Chani Maybrook, I got an email from Dr. Maybrook indicating that she had actually finished up her marital satisfaction survey. She had succeeded in getting 2,600 responses to this survey on marital satisfaction, which is pretty impressive. And she had followed my advice and thrown in a few questions about the prenup in her survey. And she invited me to work with her a little and try to understand what the responses meant, whether we could use any of this data in a positive way. And as it turns out, when you comb through the data, about 25% of respondents, again, 25% of the 2,600 respondents, had responded that they had signed a halachic prenup. 75% had not. As you'd expect, the younger the respondent, the more likely they were to sign a prenup. That's, I find, immensely encouraging. That's a big number just in its own right. And to see that 25% of a random sampling actually signed the prenup, I think that speaks well of the saturation, not saturation, but of the real tremendous strides we've made over the past 20 years in getting people to sign the prenuptial agreement. But importantly, when the data was analyzed, it showed the following. The survey calculated, or the people who analyzed the survey results calculated marital satisfaction based on the dyadic adjustment scale, which apparently is the most empirically used scale to determine marital satisfaction based on answers to survey questions. And they found no correlation, positive or negative, between having signed the prenup and the success of a couple in achieving marital satisfaction. But more to the point, the survey asked the respondents the following question. One of the questions in the survey was, how often do you discuss or have you considered divorce, separation, or terminating your relationship? Now remember, some critics of the prenup have argued that signing the prenup makes it more likely that a couple will inappropriately and prematurely think about divorce or talk about divorce or contemplate divorce in some real way. And if that's right, then controlling for other factors that would affect how this question was answered, there should be at least some bump in the line for how married people answer this question, depending on whether or not they signed the prenup. But when the numbers were tallied, the needle didn't move at all. There was no correlation at all between signing the prenup and discussing or considering the possibility of divorce. We've talked this morning about some of the reasons for signing the prenup, its benefits. Thanks to this study, we're a little farther along than we used to be in answering some of the critics of the prenup. I'd like to close with one concluding thought that I think is especially appropriate in the context of an OU convention. The development and the adoption of the prenup, I think, represents one of the signal achievements of centrist orthodoxy in America over the past quarter century. It was achieved by an extraordinary partnership between the rabbinic and lay leadership of our community. The prenup couldn't have been developed, it couldn't have been authored, it couldn't have been written without the Beis Din and the cooperation of poskim of stature, because the areas of halacha that are covered by the prenup cover some of the most complex and fraught areas of contemporary psak halacha. And just as much, it couldn't have been done without the lay leadership, the lawyers who drafted it, the community leaders who encouraged its embrace, because the success of the prenup depends on its legal enforceability, and it depends on the willingness of the men and women who will sign it to do so. Now, it's true in some ways the prenup is unique because there are few other initiatives that so perfectly marry together secular and religious problem solving in one document. But in other ways, the creative imagination and the collaboration of rabbinic and lay leadership is just as necessary across the spectrum of challenges that our community faces. Rabbinic leadership has much to gain from the professionalism and expertise that lay organizations like the OU bring to the table, and vice versa. All our institutions, I think, across the spectrum, across the board, stand to benefit from enhanced relationship building and initiatives that integrate and bring together the very best and most talented elements that our communities have to offer. I'm happy to open the floor to questions and open a discussion about the prenup. Yes?
Thank you very much for that very insightful and very good presentation.
Thanks.
Do you see any progress in the embrace of the prenup in the more so-called yeshiva world?
I'll repeat the question. The question was whether I see any progress in the embrace of the prenup among the more Haredi or more yeshivish world. The answer is not enough, because clearly we have a long way to go. It hasn't in any real way been embraced outside, or I should say to the right, of the modern Orthodox world. But we do hear some chatter, as they say, and there are some positive indications. Every once in a while, some form of dialogue takes place. We're in touch with people who are, well situated within that world. And I think increasingly, across the spectrum of Orthodoxy and even to the right, people are coming to the realization that this is just an intolerable problem. I mean, the news a year ago of the arrest of people who took quite a different approach to the aguna problem, I think woke up some people to the notion that this is just not a tenable problem. We can't continue to live in a situation where couples can't get divorced in the Orthodox community without being forced to some level, or without being exposed to the risk of some level of extortion or just an uneven playing field in divorce negotiation. So I think there's some awakening on that front, and I'm hopeful that that will, in turn, lead to further embrace of the prenup. Yeah, Naomi.
I think that many people are not aware that years ago, Moshe Feinstein had a prenup. It's on much more simple basis and level than the one that that Basic America has. But about 18 years ago, when daughter of mine was getting married, and he, from the yeshiva he was in, refused to sign a prenup, I was informed about this one, and Rabbi Dr. Moshe Tendler actually had copies of it. I sent a car service the day before the wedding to pick it up. Nobody who could argue against something like that, but most people, I think, are totally unaware of that.
Yeah, it's true. Moshe Feinstein has in his tshuvas a prenup. His prenup is a much shorter form, as you mentioned. It's really just an arbitration agreement that empowers the Beis Din. You can name a Beis Din and empowers the Beis Din to determine issues relating to the divorce. It lacks that enforcement mechanism that our prenup has, but it's true. And the truth is, even if people were to just sign that form of prenup, that would be a step in the right direction. The system as it is now, where there's no prenup signed in many communities, is just leaves it completely open. Yeah.
Two questions. One, how do you get more rabbis
Yeah, the question was, how do we get more rabbis to insist on using a prenup? And the second was, have we been in touch with groups in Israel, such as Sohar, about advocating the prenup? The answer to the first question is public awareness. You know, the Rabbinical Council of America has been instrumental from day one in getting rabbis across North America to sign it. From the very beginning, the RCA passed resolutions encouraging rabbis. Some newer organizations, such as the IRF, have gone even further and required their rabbis to sign prenups. And they deserve credit for that. There's no doubt. There's no doubt. So, you know, national organizations have a responsibility, and I think to a great extent have stepped up to the plate. We need more national organizations. We need more people of influence to encourage rabbis to do so. We have relationships with Rachel Levmore, who's an important mover of the prenup in Israel. Organizations such as Beit Hillel and Sohar have encouraged the adoption of the prenup. There's a movement even within the Rabbanut, I think now, to encourage the adoption of the prenup. That's another important frontier that will benefit from the adoption of the prenup, although clearly the situation in Israel is a different story entirely, because there the Beit Din has authority more so than Batei Din in the United States, so it's a little bit of a different situation. But clearly that's an area that needs to be also worked on. Yep.
Signed the prenup in New York. The fellow goes to California now.
I should ask Ben.
When we spoke about what I mentioned in my introduction, the issues that we were looking at this summer, that's exactly what we're trying to do, is to make sure that the prenup is enforceable in as many states as you could imagine Jews living in. And what some of the tinkering that we're doing on a regular basis of the prenup is for precisely that reason. We want to make sure that this is enforceable wherever we might find the gentleman or the couple, when ultimately Chas v'Shalom, it turns into a situation where the enforceability needs to be retained. So the answer is yes. We're trying very hard to make sure it's enforced in as many jurisdictions as possible.
I know that they're now doing the postnup. They're trying in California particularly to get to the postnup, just because of this problem.
Yeah, California. Yeah. Sorry. I don't. This is Rabbi Weissman's show, but you know I'm a lawyer, so it's hard for me to resist the podium. You're exactly right. The postnup, California in general, I don't know if, and I don't mean to offend anyone from California, is the most difficult jurisdiction when it comes to marital matters, because they have very different, strange, idiosyncratic laws when it comes to this stuff. And I would say that, I don't know, 50% of the time we spend worrying about the prenup, we worry about California, and we address issues that are unique to California. But we're certainly tackling it, and we're hoping that the version that we have now would be enforceable in California like it would be in New York or New Jersey or anywhere else. But it's interesting that you mentioned California, because that is a thorny jurisdiction because of its unique laws when it comes to this area.
Yeah, for years we've had a separate California version of the prenup that's been really difficult. It requires both sides to have lawyers, or at least both to sign the waiver of lawyer representation, full financial disclosure. It's a pain in the neck of a document. We're actually, in the next few weeks, hopefully, rolling out a new California version that we hope to be much more streamlined. So that's a development, hopefully, in the realm of the prenup.
But what I meant is basically you should have everyone sign a document so that it would be enforceable in the various states, because you don't know what's going to happen in the future.
Yeah, no, the expectation is,
Separate one.
yes, the expectation is, and especially now with the new form, the new California form, the expectation is that prenup signed in New Jersey will work in Idaho and will work in California. We're tackling that problem. Yep. Yes.
Has there been any instance in which a get which was obtained after prenup was signed has been subsequently challenged as obtained with popular power?
No. Meaning the get that's done under the guise of the prenup, where the prenup is sort of lurking in the background, follows the typical formalities of any get done at the Beth Din of America. getting done at the Beth in America are universally accepted by the Rabbanut and elsewhere. We've never run into a problem of someone challenging the propriety of a get that's been arranged by us. Yep.
What percentage of modern Orthodox rabbis require prenup? What percentage of the RCA, of Wayulam, of the Agunah, we'll say that? You know, as you said, that the IRS and the YCT, it's 100% compliance, and especially in light of the relationship between the RCA and the Tevet of America, you spoke about universal acceptance, and it seems that if rabbis required it, it would be universally required and accepted. So can you tell me about the situation and what the Tevet of America is doing to move that idea along?
What we're doing to move along a near universal requiring of the prenup is education, events like this, getting the word out, and trying as much as we can to influence the public debate and to get people more aware of the prenup as a solution and as an effective solution. The answer, in terms of percentage, we actually conducted a survey of RCA rabbis in 2009. And I don't have the results here. It was not 100%, clearly, but it was a high percent. And I could tell you that among the RCA rabbis that are rabbis of big shuls, that are the more prominent and influential, and that perform the more weddings in America, I think that you'll find that the vast majority of them either require the use of a prenup or highly encourage the use of a prenup. And I also think that the trend is moving in the right direction. And as time goes on, and as we share more and more stories of the prenup having succeeded in its goal of getting a get in a timely manner, more and more rabbis become aware of the fact that this is just something they need to require, that they need to encourage marrying couples to sign. So it's moving in the right direction. I think I hope at some point we could say that it's been universally adopted. The truth is that the RCA has a diverse membership, and each rabbi. We live in America, which is a free country, which means that rabbis have the autonomy to make decisions on their own. But the RCA, I think, should be commended for spreading awareness among its rabbis of the prenup, for educating its rabbis about the importance of the prenup, for passing resolutions year after year about the prenup, and for raising awareness among the community. Yes?
Have you ever had experience with a couple who signed the prenup and then signed to go to a Haredi Bezdin with the divorce? And if so, how does the Bezdin accept the prenup?
The question was whether we've had situations where a couple signed the prenup and then went to a Haredi Bezdin for their get. How did that Bezdin deal with the issue of the prenup? The answer is that if you go to any Bezdin, if both parties present themselves and say, we're ready to do a get, it's pretty much of a pro forma event. You do the get. The prenup really comes into play in a situation where one side is prepared to give a get, the other side's not prepared to give a get, typically where the husband is the recalcitrant party. And in those situations, let's say, for example, where a husband insists on going to a different Bezdin, and the wife has a prenup in her hand and says, I want my get now, the prenup solves that problem, because the prenup names the Beth Din of America as the Beth Din with authority to determine that case. The husband loses his ability to insist on going to another Bezdin that might be more sympathetic to his desire to delay the giving of the get. So that's one of the, in terms of the mechanism of how the prenup works, that's really how it works. The wife has the benefit of now saying, no, you have to come to the Beth Din of America. We could then act unilaterally, even without his cooperation, and start charging him the support obligation if he doesn't give the get. Yeah.
You mentioned about more right-wing Jewish places. What about conservative Jewry? Are they accepting of this prenup mechanism?
The question was whether conservative Jewish rabbis or conservative Judaism accepts the prenup. The answer is it's really a different landscape when you talk about marriages performed by non-Orthodox clergy. Thanks to Rav Moshe Feinstein, who was the pioneer in this area and really paved the way for us in terms of dealing with status issues that arise from the need for a get. A wedding performed by a non-Orthodox clergy person, at the end of the day, in just about all cases, very often. If a spouse refuses to participate in the get process, there are sort of other ways that we can look at the case and hopefully free the woman to remarry if it wasn't an Orthodox wedding. Obviously, it's a case-by-case determination, but for that reason, non-Orthodox weddings present much less of a high risk of Agun. Conservative Judaism has kind of solved the aguna problem in their own right because they do things like Hafka'at Kiddushin, where they just kind of have a magic way of solving the problem even if without a get, if the husband refuses to give a get. So in a sense, they don't need the prenup because they could just dissolve the marriage on their own through whatever mechanisms they've come up with. So the answer is that the problem of Agun doesn't really present itself in the same way in the conservative or reform context, and the prenup isn't as necessary in that context.
You indicated that in the study by Dr. Maybrook, the needle did not move when the prenup was signed through the discussion for bringing up divorce. Is there any information on that with the postnup?
Okay, the question was whether in the Dr. Maybrook survey or in the study, the signing of a postnup had any effect on bringing up issues of divorce. That's an excellent question. I don't know the answer because I don't think it asked about the postnup, although I guess we'll have to look. It's a good question. I don't know the answer. I don't know the answer. Yes. I'm sorry? Sure. The question was, can I explain further what the postnup is all about? Postnup is really the equivalent of the prenup, but for people who are already married. A prenuptial agreement is signed prenuptially, before nuptials, before the marriage. A postnup is signed by a couple that's already married who want to sign on to the terms of the prenup. And so it's just a very slightly modified document that makes it clear this couple's already married and they're agreeing to adopt these provisions. Yeah. Sure, yeah. The question was whether the Beth of America has any influence or ability to convince organizations aligned with the Beth of America to adopt the prenup. Look, the answer is that for organizations aligned with the Beth of America, meaning organizations like the OU, the Rabbinical Council of America, they have taken great steps in promoting the prenup. Beyond that sort of centrist Orthodox community, we don't necessarily have the influence and ability to get people on board with the prenup. There are dialogues that have taken place over the years, conversations that have taken place. We've not been shy about the success of the prenup. We try as much as possible to share with the world how the prenup has been successful, and we hope that in the long run will influence others to adopt it.
Fledgling Orthodox communities throughout the country. Are there states that are proving to be especially difficult in getting them on board with this, where, on the other hand, there are communities the OU would like to promote?
The question was, the OU has been at the forefront of encouraging people to move to more far-flung communities outside of the New York area. Are there states that we're particularly concerned about the enforceability of the prenup, you mean? Generally speaking, Davis Polk, I should mention the generosity of Davis Polk, which is Ben's law firm, in terms of devoting those hundreds of hours this past summer in reviewing the enforceability of the prenup. They deserve a lot of credit for that. They conducted, when we first talked about how we should do this study, I went on Google and I found the 9 states with the highest Jewish populations. It's a fun lunch table game to guess which 9 states have the highest Jewish populations. And they found that in those 9 states, and I think they went even further and looked at 25 states even, the laws governing the enforceability of prenuptial agreements, and specifically this prenuptial agreement, were pretty much all on board except for California, which has its own rules. But other than California, everyone's kind of in the same boat. There's a uniform prenuptial agreement act that many states have passed. And so generally speaking, there's not one particular state other than California that that concerns us. I wouldn't be worried about moving to a community in Texas, for example, even if it's not necessarily one of the states within the 9 top Jewish population states. So the answer is not really. Yeah.
First of all, I want to thank you for an excellent presentation.
Thank you.
So articulate.
Thank you.
But I do have a question. I think this whole concept is wonderful, and it sounds like it could solve the whole problem. But I want to know, did the RCA ever sit down in a room with Rosh Yeshivas of Mir, of Chaim Lim, of Torah Vodaas, of Lakewood, of all more right-wing orthodoxy, or as you said, the Haredi world in America? Because that's where the problem is. OU is doing a great job enforcing it, and so is RCA. But it's the other end of orthodoxy that I think is a problem. Did you ever literally sit in a room like this at a table with all the Rosh Yeshivas and who performs the ceremonies? What is that called?
Masadre Kiddushin, right? Right.
That's what I read.
The answer is no. There's never been a summit where everyone sat around the table, and I agree. You could organize it, meaning we're all in favor. Okay, we're on board. Meaning Rabbi Willig will show up. He told me he'll show up anytime, any place to advocate the prenup. He's the man to do it. He can speak the halachic lingo, and but the truth is, that's the question. How do you get them to come? So the answer is perhaps you need people who are members of their communities to try to organize those kind of meetings. We're ready to show up. We're happy to participate.
Get
The
the Rebbitzins.
Rebbitzins.
They don't care about the Rebbitzins.
I don't know if that's true, but to some extent, there have been conversations. It's not as if we're talking about 2 completely isolated communities. There are conversations that take place.
Because these rabbis won't even be in the side under chuppah if you even talk about a prenuptial. They won't do it. They tell the couple, I don't do that if you want to sign that.
Until their daughter.
My experience has been that in situations where a Masader Kedushin who does not otherwise advocate the prenup, in situations where he's presented with the prenup, and let's say, for example, the Kala comes from a family that insists on the prenup, they've gotten comfortable with it, indicating that the objection is less halachic and more cultural. In those isolated events where even Masader Kedushin who are prominent and have relationships with prominent poskim within the Haredi world, situations where they've been presented with the situation, they've accommodated it. They've accommodated it. So that might be perhaps a pathway towards spreading the use of the prenup. Literally bringing it up on a case-by-case basis as people get married. To say, look, I'm a member of your shul, I'm a member of your community, you are my Rosh Hashiva, you're going to be my Masader Kedushin, but in our family, we feel strongly that this is an important document, this is an important communal problem, and it needs to be solved case by case. We need to sign this prenup, and maybe if enough people do that time after time, in a respectful way, and cognizant of their halachic authority. But again, I think that these are conversations that could take place, and there's an accommodation that can be made on a case-by-case basis over and over again that maybe that will help spread the use of the prenup. Yeah.
I'm going to go to the other end of the spectrum. How much have you coordinated the content based on the state need to keep this within a secular acceptability as well? How much have you coordinated with leaders of other religious bodies, or the Catholics, for example?
We haven't coordinated with other religious bodies because I think that this problem is a unique one to Judaism.
No, but the question is to get the support of state legislators.
Oh, I understand what you're saying. I'm sorry. The question was, to what extent have we sought to enlist the support of other faith communities to get state legislatures to be more open to passing legislation that will allow for the enforceability of the prenup? Yes, I think the answer is that organizations like the OU, which have a robust advocacy arm like OU Advocacy, work with other faith communities on a daily basis to pass legislation. And to the extent that we needed to enlist that kind of support, we could. But the reality of the situation is that the prenup is enforceable under existing laws, thankfully. But I agree, that would be a way to go if we needed to. Yeah.
I know the topic is pre and post up, but I think maybe you would just spend a minute or two on Moshe and Mishpat usage of the Beit Din, which I think is a very valuable contribution to the
Thank you. That's a good opening. Thank you, Mr. Urban. I'll take the opportunity. One of the things that the Beth in America does is focus on the prenup and resolve aguna cases. That's an active part of what we do each and every day. It occupies a good amount of my time. But another service that we offer to the Orthodox community and to the entire Jewish community is arbitration of commercial cases. The halacha is that where Jews have a dispute, the appropriate venue for resolving that dispute is a Beis Din, is a Jewish court of law. And we are unique among the Batei Din that are out there in terms of the legal professionalism and expertise with which we attack these cases. Parties that bring cases before us sign a binding arbitration agreement, and we conduct proceedings that look very much like secular arbitration proceedings, but that are really Torah-based Dinei Torah. And we issue, we staff the cases with panels consisting not only of world-renowned Talmidei Chachamim, experts in Choshen Mishpat and Jewish law, but also a mixture of businessmen, attorneys. Some of the Dayanim are both rabbis and attorneys. That's vital because very often the right answer to a case depends not necessarily or not exclusively on how Jewish law looks at a problem, but on also what secular law has to say about a problem, what the common commercial practice is that might govern the outcome of a case. And so we staff the cases with that diverse group or that diverse mixture of expertise. We issue reasoned decisions. As Ben pointed out, over the last few years, we started to publish those decisions so you could get a sense of what the decisions look like, how they bring that expertise from both Choshen Mishpat and from secular law together in a rational way. We are governed by a written set of rules and procedures that look very much like secular arbitration rules and procedures, but again are Torah-based arbitration. You could go on our website and read all about this and get download examples, bethdin.org.
But just do one or two more questions because we have to change over the room. And Brian Weissman's available he's very engaging, I know, but he'll be available to take any questions afterward. Please go. Yeah, please.
20 years ago, Rabbi Luli went to Israel and got the approval of several prominent rabbis when he wrote this prenup agreement. The question I wanted to ask was, have you adjusted the fine in the 20 years? It was a very low fine when it was established. We wanted it to be one that would be practical. But there's been a lot of inflation in the last 12 years.
That's a good question. I'll repeat the question. The question was 20 years ago when Rabbi Willig first went to Israel to secure the support of some of the Gedolim for the prenup. The fine was set at a certain low amount. Have we adjusted that? No, I shouldn't say fine. The support obligation was set at a certain low amount. Have we adjusted the support obligation since then for inflation? So first of all, it's important to note that the agreement itself contemplates inflation and adjusts the daily support amount based on the consumer price index. So if you got married in 2004 and the rate was $150 per day, now it'll be about $170 per day based on inflation. The original agreement that was first published in 1994 set the rate or set the support obligation at $100 per day. In the early 2000s, the form raised it to $150 per day. So now the standard form sets the support obligation at the date of marriage at $150 per day, and then it adjusts for inflation thereafter. We're ready to peg it up to the next increment, which will probably be about $200 a day, but we haven't quite hit that yet in terms of inflation. We check about every year or two, and we're hovering now. If you figure that 150 a day as of 2003, when I think it was set, we're now like 170 or 180, and we don't want to jump the gun. But probably in a few years, we'll jump it up to 200.
Last question, please.
Yeah.
What, if anything, is being done about the situation you mentioned? Sorry. Judgment-proof individual, or the person is so wealthy that they just don't care. What's being done about those situations?
The question is, what do you do about a situation where someone's judgment-proof or so wealthy that they don't really care? I worry more about the judgment-proof cases than the someone who's so wealthy they don't even care, because what we found is that even really, really wealthy people don't want to pay their ex-wife $50,000 a year. They just don't like doing that. Judgment-proof people, those are the cases that really scare me. A few years ago, we had a case of a guy who was declining to give a get. He had signed a prenup, and he was living out of his car. He was on drugs. He was like completely off the grid. And I really worried about that case. And thankfully, the case resolved itself. Part of the solution was that we were able to get him into the room, thanks to the prenup. The prenup itself just got him into the room. A person like that who was in touch with all sorts of characters, in a case without a prenup, he would have named some other bezdin. He would have said, I want to go to, some bezdin that my uncle has in his basement. It would have been a really difficult situation even to issue a seder against a guy like that. But because he had signed a prenup, we were able to get in the room, and the dayanim, Rabbi Wula, can be really, really charming and convincing when he's dealing with a ma'agin. He's really very good at that, and that worked. The guy gave the get. So those are the cases I worry about, and the answer is that the prenup won't solve every last case. It's been enormously successful, but it won't solve every last case. But it's an entirely different problem communally when you have a problem that affects a few people than when you have a systemic problem that affects many. And in that sense, I think the prenup is really the solution to the problem.
We want to thank Rabbi Weissman, and we want to thank the Orthodox Union. I should have mentioned the Orthodox Union is the largest supporter financially and otherwise to the Beis Din of America, and we appreciate that. And we appreciate Dr. Tannenbaum allowing us and giving us this forum. Rabbi Weissman will be available for questions now. Thank you.
Thank you very much.